Okay, interesting question. You're twins, 10 years old, you live in Georgia, local school systems have been refusing to do any evaluations for an IEP or 504 since March of 2020 when the pandemic started due to COVID lockdown. School has now set up prerequisites for evaluation and includes requirements that you got to have broadband internet installed, blah, 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 so forth, so on. You live on a farm, there's no access to internet, much less broadband. This includes hotspots due to distance, and so forth. And you asked about the use of CARE Acts. They used it for district salaries and bonuses, which many did. You filed complaints with the Georgia Department of Ed. Both are ignoring your complaints. Well, I'm sure it takes time. I don't know what the current status is. And let me go ahead and tell you, they're wrong. That there was no moratorium on not doing evaluations, all right? The federal government did not provide any kind of waivers. The state government cannot provide those waivers in absence of the federal government doing it, okay? These are federal funds first and foremost and state funds on top of it, but they've got to comply with the federal regulations. And last summer, the Trump administration did not give waivers to the public school system on adherence to these rules, despite the lockdowns and despite the continuing pandemic. Biden administration hasn't announced any changes either. So the Trump era refusal to provide waivers are still in effect, hopefully, cross our fingers. That being said, to put additional requirements on a family that include exorbitant expense, especially out in rural areas to where you just don't have broadband and you just don't have these things, that is outside of the parameters of the law. The school could get into some big trouble. And yes, there is CARES Act money, the money that was given to schools way back then, and then you got a whole bunch more coming their way to sit there and try to alleviate these problems. And if they actually admitted to you, please, in writing, I hope, that, well, we spent it on salaries and bonuses, but yet, we can't evaluate your children. And I know you asked this question a few months ago, but if they started the evaluation process, typically they're going to try to kick the can. I saw when you asked this question, and it was right at the beginning of summer. And more than likely, they were just kicking the can and giving you excuses until the beginning of the school year because they didn't want to evaluate over the summer. If that was the case, please remember this. They can feed you every line of bull. And even the people feeding you this misinformation, this wrong information, they may be absolutely confident in the information that they're providing you that they themselves believe it's accurate. It's not accurate. There is no waivers. The law is still in effect. They needed to evaluate. That continued. So this is the kicker. They didn't do it. So let's say that they do evaluate your children, and hopefully they've started that process. And I don't care if the Georgia State Department of Education is involved, and I don't care if OCR is involved. It doesn't prohibit or impede your right to seek compensatory services in the form of damages. They did not evaluate your child, which meant that when they do, if you can sit there and track it back to when you first made the request or when the district knew, suspected, or should have known that your child was one that needed to be evaluated, that could have qualified or should have qualified back then your child is entitled to services backdating to, let's say, March, maybe even before March of 2020. Okay? You have a 2-year statute of limitations in Georgia. And so at that point, that's the standard. I understand that they delayed you. But let's say that they finally evaluate your children and they're found eligible. How do you calculate your entitlement of recovery services for your children because of their ignorance and their refusal to follow the law? You track it back to when they knew, when they should have known, when they suspected that your child needed to be evaluated. And at that point, I would press it. And I don't care whether your child has an IEP now or a 504 now. That doesn't negate the fact that you have a case to track it back and get those recovery services for where they failed you. Okay? That's how you get their attention. That's how you get things to change, guys. You got to hold them to account. There must be consequences to some of these administrative decisions that are not backed up by the law whatsoever.